Hello, welcome to Epstein, Becker, and Green's Class Action Avoidance series. This is part one of three, all of which are being focused on wage and hour law. I'm Jeff Ruzal, and I'm a member of Epstein, Becker, Green's Employment, Labor, and Workforce Management practice here in the New York office, where I represent employers in, among other areas of employment law, the defense of wage and hour class and collective actions throughout many industries, including financial services, retail, healthcare, hospitality, and technology. Many of these wage and hour lawsuits are based on claims of misclassification, failure to pay for all time worked, overtime pay violations, frequency of pay violations, meal and rest break related issues, and unlawful tip credit and tip pooling issues. Prior to joining Epstein, Becker, Green, I served as a trial attorney for the U.S. Department of Labor, Office of the Solicitor in New York, where I was responsible for civil enforcement of the Fair Labor Standards Act and its implementing regulations from wage and hour investigations through trials. Wage and hour class and collective actions are a significant part of employment-related litigation, and there's no sign that this area of litigation will abate in the near future. The reason many wage and hour lawsuits are filed as class and collective actions is because, quite frankly, it's easy for the plaintiff's bar to do so. Typically, class and collective actions involve only one or two named plaintiffs, as plaintiff's counsel need only establish at the outset of the litigation that the other current and former employees of the defendant employer are, quote, similarly situated to the named plaintiff, and that there was a common policy, plan, or practice that underlies the purported wage and hour violations at issue in the lawsuit. Most federal district courts throughout the country apply a liberal standard for preliminarily certifying FLSA collective actions, and it's not until after class and collective-wide discovery has been completed that employers are able to challenge during Rule 23 class action certification and FLSA collective action decertification motion practice. In addition, violations of wage and hour laws and regulations provide for extensive relief to plaintiff employees, including statutorily mandated liquidated damages in the form of 100% of the back wages or overtime found to be owed, as well as shifting attorney's fees, meaning that employers must pay plaintiffs reasonable attorney's fees, which, in a class and collective action framework, can be quite expensive. In short, it's very costly, time-consuming, and distracting for employers to defend against wage and hour class and collective actions, so it is imperative that employers ensure that strict policies and practices are in place to avoid potential exposure to the typical allegations that manifest in claims for unpaid wages or overtime. As I mentioned in my introductory remarks, I devote a good deal of my practice to the defense of wage and hour class and collective litigation. However, I also spend significant time counseling clients on litigation avoidance, which is the purpose of today's webinar. Today, I will be focusing on wage and hour issues that could result from work from home policies and practices on account of the ongoing COVID-19 pandemic. As fall approaches, businesses are deciding whether to fully reopen, maintain a largely remote workplace, or provide employees the option of working in the workplace or at home through a hybrid approach. Recent reports and surveys have shown that many remote workers throughout the U.S. have been, on balance, satisfied with their current work from home arrangements, as it has in many cases allowed workers to take more frequent breaks from work, including time spent outside their homes, while maintaining on par or even greater productivity than when historically working in the office. While this arrangement might prove mutually beneficial to employees and their employers, it is critical that employers are mindful of the potential wage and hour issues attendant to working from home scenarios. There are two issues I will be focusing on today. One, ensuring that all work time is properly recorded and paid to employees who are not exempt from overtime. And two, properly maintaining exempt status for managers and supervisors who are also working from home. Off-the-clock work features as a typical claim in wage and hour class and collective actions, the reason being that employers have a statutory duty to accurately and contemporaneously record all time worked by non-exempt employees, and that in the absence of such accurate and contemporaneous records, employees are permitted to put forth any evidence, including self-serving testimony, that they worked a greater number of hours than that for which they were compensated. The burden then shifts back to the employer to present evidence to rebut the employee's self-serving testimony and evidence. However, in the absence of bona fide records, The only real defense is to challenge the credibility of the employee, which a jury may not be able to fully appreciate. Thus, work from home practices may be susceptible to off-the-clock claims if employers fail to maintain strict policies to ensure that all work time of its non-exempt workers is recorded and paid. In fact, the Wage and Hour Division of the U.S. Department of Labor issued a Field Assistance Bulletin 2020-5 just today to specifically address teleworking in the age of COVID-19. The bulletin reinforces the employer's obligation to compensate employees for all hours worked, which is based on actual or constructive knowledge of that work. The Wage and Hour Division explains that for telework and remote work employees, the employer has actual knowledge of the employee's regularly scheduled hours, and that it may also have actual knowledge of hours worked through employee reports or other notifications. The FLSA standard for constructive knowledge in the overtime context is whether an employer has reason to believe that work is being performed. An employer may have constructive knowledge of additional unscheduled hours worked by their employees if the employer should have acquired knowledge of such hours through reasonable diligence. To help avoid off-the-clock work claims, employers should develop a policy whereby non-exempt employees are required to record all work time in writing each day. For non-exempt employees who work defined daily shifts, there should also be policies restricting employees' work time to such defined shifts, and provide that while all work time will be compensated, there will be disciplinary measures taken against employees who work unauthorized time outside of their shifts. If employees are permitted to work outside specific shifts, but employers do not want those employees working more than 40 hours a week, which would trigger overtime pay obligations, then employers should maintain a policy to that effect, which with the same disciplinary measures imposed against employees who perform unauthorized work beyond 40 hours in a week. By requiring employees to record their work time and informing them that they will be paid for all time actually worked, employers are protecting themselves from potential off-the-clock claims because it will be difficult for enterprising plaintiffs' attorneys to claim that employers, who effectively are taken out of the equation, fail to report all work time. Part of the efficacy of this approach is the ease with which employees can actually report their work time. It's important that employees are able to use a simple time recording instrument to record all time so that they cannot later claim that the process was either too complicated or otherwise prevented them from accurately and contemporaneously reporting all of their time. There are many apps available on personal computers and smart devices that provide easy methods by which non-exempt employees can record all work time, and, if all else fails, a simple policy that non-exempt employees self-report all of their work time in writing via email to their direct supervisors will likely do the trick. Another off-the-clock issue of which employers should be aware is meal and rest breaks. Many jurisdictions, such as California, provide for specific meal and rest breaks throughout the day. The FLSA provides that all breaks of 20 minutes or less must be compensated, and that only breaks of 30 minutes or greater can be non-compensated. However, non-exempt employees must be fully relieved of work during these breaks. These laws and regulations apply in the same manner to employees working from home. Thus, if a non-exempt employee is provided a 30-minute break each day, it's important that a written policy is put in place that clearly states that non-exempt employees are not permitted to perform any work during their breaks, and that in the event any work is performed during that time, they are required to record such work time and inform their supervisors that they were not relieved from work during that break time. The last point I want to make clear about off-the-clock work is that policies are only effective if they're enforced. So for that reason, it is crucial that managers are thoroughly trained in all aspects of these policies so that they can effectively and precisely enforce them. The next and last work from home issue I will be discussing today is properly maintaining exempt status for managers and supervisors. Exempt managers and supervisors are typically exempt from overtime pursuant to the executive exemption. There are two prongs that must be satisfied in order to qualify for the executive exemption. First, employees must be paid on a salary basis as opposed to an hourly wage. and at a weekly threshold of no less than $684 per week, which is $35,568 per year. Please note, very importantly, that certain state jurisdictions maintain higher salary threshold requirements, such as New York, which can be as much as $1,125 per week, which equates to $58,500 per year. The second prong of the executive exemption is often referred to as the primary duties test, which provides that certain exempt qualifying duties must be performed as a primary basis of the worker's employment. Certain states have quantified the amount of time that must be spent performing exempt qualifying duties, such as California, which requires that it must be 50% of all work time or greater. Although the FLSA does not specifically quantify the percentage or amount of time to constitute, quote, primary, federal regulations and U.S. Department of Labor interpretive guidance provide that it should be customarily be more than half of the employee's work time. The duties that qualify for the executive exemption include regularly supervising at least 2 full-time employees, plus engaging in activities that carry the typical badges of management, such as hiring and firing, conducting performance appraisals, being involved in making or recommending promotions or salary adjustments, and imposing discipline or suspensions. Generally speaking, employers have faced many challenges in the COVID environment, which has resulted in salary cuts or modifications in duties performed by workers across each respective business. With respect to the first issue, the salary issue, employers must pay exempt employees the same weekly salary without regard to the number of hours or days worked each week. Thus, employers will jeopardize the exempt status of their managers if they reduce their exempt employees' salaries commensurate to the amount of their work time. It is permissible to reduce an exempt employee's compensation as long as it does not fall below the relevant jurisdictional salary thresholds. However, it is important to make clear to the employees whose salaries are being reduced that it is not based on any in-kind reduction of their work hours. Put another way, there cannot be the appearance that exempt workers' salaries are based at all on the number of hours they work each day or week. With respect to a potential change in job functions, there may be a need for more experienced employees, such as managers, to perform higher level business functions and, in the process, whether inadvertent or not, shed their supervisory functions. Unfortunately, there is unyielding stringency to qualify for exemption from overtime, which is measured on a work week basis. Therefore, it is important that employers make sure that exempt managers and supervisors remain above the federal and state salary threshold requirements and that their primary responsibilities continue to be managerial in nature. These two issues figure as the likely predominant areas that could lead to wage and hour, class, and collective treatment. Therefore, it's important for employees to address their policies and enforcement as soon as possible. I hope that today's webinar has been helpful, and I always invite you to reach out to me or my colleagues at Epstein, Becker, Green with any comments or questions you may have. Also, please download and use Epstein, Becker, Green's federal and 50 state wage and hour app, which is complimentary and available for both iPhones and Android devices. Thank you.